Good afternoon, everyone. From day one unfair dismissal rights to changes to redundancy consultation obligations and the recent Supreme Court ruling on the Equality Act definition of a woman and a man, there is a vast amount for employers to get to grips with over the coming months and years. And in our webinar today, we'll bring you up to speed on the key employment law developments you need to be aware of and help you prepare for the changes ahead. I'm Stephen Miller, an employment partner in the Clyde Co Glasgow team. I'm joined today by legal directors Matt Harrop and Laura Kings. If, as we go through, you've got any questions that we don't cover during the webinar, please put them in the Q&A box and we'll endeavour to respond to you either during the webinar or afterwards. As we're turning to the agenda for today, which you see now, we'll start with a quick recap on the key recent developments. Then we'll take you through what's coming up in employment law and touch on some recent cases as we go. And we'll finish by looking at the key recent Supreme Court decision in For Women Scotland and to analyse what that means for employers. And so I'd like to turn to you, Laura, first to take us through some recent developments, beginning with sexual harassment.
Thank you, Stephen. So we're going to start with a quick recap on the key recent developments in employment law. So since the 26th of October 2024, employers must take reasonable steps to prevent sexual harassment of their workers, and that's called the preventative duty. Importantly, that duty extends also to protection from sexual harassment by third parties. So if your employers are interacting with clients, members of the public or other third parties, you do have a duty to take reasonable steps to prevent sexual harassment of your employees by them too. So the bite of that is that if an employment tribunal does conclude that a worker has been sexually harassed, it must consider whether the preventative duty has been met, and if not, the employer can be ordered to pay an additional 25% maximum on any compensation awarded. There's also a potential for the Equality and Human Rights Commission to take enforcement action against employees, and of course, where you have findings made of a breach of this type of duty, there may well be reputational and, where applicable, regulatory consequences too. Another update which came in earlier this year related to fire and rehire. So sometimes employers need to adapt the way they work, and to achieve this, they might need to change their employees' terms of employment. The term fire and rehire refers to the practice of changing employment terms and conditions by way of dismissal and re-engagement, typically in situations where it hasn't been possible to obtain employee or trade union consent. A new code of practice on fire and rehire was introduced in July 2024 with the aim of encouraging employers to act fairly and responsibly in negotiations over changes to terms and conditions, and emphasising that fire and rehire should only be used as a last resort. From the 20th of January this year, tribunals were given the power to increase certain tribunal awards by up to 25% for failure to comply with the code. In summary, the change means that if an employer fails to consult with employees about the proposed contract changes and uses fire and rehire to secure employee employment on the new amended terms, they risk a 25% increase in the amount that they could be required to pay out for a claim for failure to properly inform and consult employees about a redundancy process involving 20 or more employees. A new right to statutory neonatal care leave and pay also came into force on the 6th of April 2025. Now, this new right gives parents of babies born on or after the 6th of April 2025 up to 12 weeks leave and pay when their baby needs specialist neonatal care for at least 7 continuous days within the first 28 days of birth. Neonatal leave is a day one right, but parents need 26 weeks of continuous service to qualify for neonatal care pay. Now, this leave and pay is in addition to existing leave entitlements that the parents may already have, such as maternity, paternity, and adoption leave. The leave must be taken within 68 weeks of the birth, and the new rules do try to build in flexibility around when the leave is taken, but there is some complexity to the way they work, so do take advice if needed. So what should employers be doing? So if you haven't already, review and update your family-friendly policies to include provision for neonatal care leave to ensure that they provide for at least the minimum statutory entitlements. And we can, of course, help with this and have a template policy that can be adapted for your business. Now, let's take a look at what's coming up in employment law going forwards. There are a lot of new changes to come, so we've broken these down into the topics shown on this slide. I'll be covering new business risks for employers and the termination of employment, and then Matt and Stephen will be talking about DEI and workplace culture, family-friendly and employee wellbeing, zero-hour contracts, and enhanced trade union rights. So to start with some upcoming changes which create new business risks for employers. Firstly, from the 1st of September 2025, where fraud is committed, large employers will be liable under a new corporate criminal offence of failure to prevent fraud unless they can demonstrate that they have measures in place to prevent fraud by their employees or other associates. Now, a large employer is one that meets two or more of these three requirements. So number one, a turnover of over £36 million. Number two, total assets of over £18 million. Or number three, over 250 employees. To avoid criminal liability, employers need to ensure that they have appropriate measures in place. And there has been guidance issued by the Home Office which sets out the types of fraud covered by the offence and reasonable fraud prevention procedures that employers should undertake. So it's worth having a look at that. So what should employers do to ensure that you have a robust defence? So firstly, carry out a comprehensive fraud risk assessment. Think about which areas of your business are more likely to be vulnerable to fraudulent activity. For example, sales-focused roles where employees are paid commissions or bonuses, which could be improperly motivated to be dishonest or misleading in order to boost sales, or perhaps roles involving investment advice, which may be vulnerable to abusing a position for gain or dishonest practices in financial markets. Next up, think about how to implement suitable fraud prevention measures. Now, there's no one size fits all, and the procedures to prevent fraud should be proportionate to the risk. Next, consider updating employment contracts and policies to cover the prevention of fraud and make clear that failure to comply with the employer's requirements on fraud prevention will be treated as a disciplinary matter, which could lead to dismissal and reporting the individual to the police and regulator if applicable. Monitor and review your fraud detection and prevention procedures. Have a look at whether they are sufficiently robust. And publicise your whistleblowing policies and procedures so that employees feel comfortable coming forward and notifying you of employee misconduct, which may include fraud. Next up is criminal conduct and NDAs, or non-disclosure agreements. So new rules governing NDAs look set to come into force on the 1st of October 2025. These new rules will prevent employers using NDAs and confidentiality clauses if they prevent victims of crime from reporting criminal conduct or making several other types of disclosure related to criminal conduct. If the clause prevents a victim of crime from disclosing information to certain categories of people, then they will be unenforceable. So, for example, that could include disclosures to the police to enable the police to investigate criminal conduct, a qualified lawyer who's providing advice in relation to the criminal conduct, or to a victim support service or the victim's child, parent, or partner for the purposes of obtaining support in relation to the criminal conduct. So what should employers be doing? So first is to check your confidentiality provisions, including those set out in your contracts of employment and settlement agreements, to make sure they don't breach these new rules. The usual way to deal with this is to include carve-outs that permit employees to make certain types of disclosure. And of course, that's another thing we can help you with by updating the standard wording in your agreements. The government has also announced that it plans to extend the requirement for businesses to carry out right-to-work checks to anyone working in their name. This is expected to include gig economy and zero-hours workers, and businesses could face a civil penalty of up to £60,000 per worker if they fail to carry out the required right-to-work checks. We're waiting for further details, including when this will come into effect. But you might want to amend agency agreements or contractors with contractors to cover this. And finally, the final business risk area is the extended time limit for tribunal claims. So the Employment Rights Bill indicates that the time limit for bringing all employment tribunal claims will be extended from 3 months, which it currently is, to 6 months from October 2026. So the impact of this is, firstly, employees will have longer to bring claims after a dismissal or an unlawful act occurs. meaning they may well find it easier to hit that deadline and not be time barred. It also makes it harder for employers to defend claims as witnesses' memories fade, and with the market as it is at the moment, employees often move on to new employers and it's harder to get them to come back and be witnesses. So what can you do to help that? Largely encouraging a practice whereby clear, contemporaneous notes are taken by HR and managers when dealing with processes so that you have these to fall back on to aid with memory. Next slide, please. Thank you. So looking now at termination of employment and the Labour government's employment law reforms in this area. And some of these are the sort of most big and headline grabbing changes relating to employment that are coming up. The primary one being the change to the law on unfair dismissal with protection coming in from day one. So under the current law, employees do not have the right to bring a claim for unfair dismissal until they have 2 years of service. Therefore, from the two-year mark, to dismiss an employee fairly, you need a fair reason and you need to follow a fair process. A key Labour government proposal is to give all employees the right not to be unfairly dismissed from day one of their employment. This is a significant change that will give many more employees the right to claim unfair dismissal, and the government has estimated that this will be around 9 million more employees the right. There is planned to be a light touch dismissal process that applies during the initial period of employment, like a probationary period. The government has expressed a preference for this initial period to be 9 months, but we're awaiting further details for confirmation of that. The government has said that the light touch process will include a meeting with the employee to discuss concerns, with the employee being allowed a trade union rep or a colleague to accompany them. Where employers decide not to keep a new hire on beyond the end of their probationary periods, they will have to either terminate the employment during the probationary period or give notice to do so before the end of the probationary period. The dismissal must then take effect within 3 months of the end of the probationary period for the lighter touch dismissal process to apply. This means the lighter touch process can effectively apply during the employee's first year of employment. And employers may still face claims from employees dismissed during their probationary period. Clearly, employers will still be able to dismiss after this period, but it will just need to use more robust and potentially lengthier processes. The lighter touch process appears not to apply to redundancy dismissals or to dismissals for some other substantial reason when they're not related to the employee, and that means those employees will have a full right to claim unfair dismissal from day one of their employment. The government has committed to a full consultation on the detail of the proposals, and that will include what compensation will be available for unfair dismissal claims during this initial period of employment. Now, we've recently heard that this is now due to be effective from 2027, not autumn 2026, as previously foreshadowed. So what should HR be doing? So bolstering recruitment and vetting processes. Look at your recruitment processes and check that they're robust. The key point is getting the right people in the door in the first place so that you don't need to be dismissing quickly for performance and conduct related reasons. For new employees with poor performance or conduct issues, we suggest mandatory line manager check-ins on at least a monthly basis as a minimum, with written documentation to support and evidence the process. Tightening up capability and performance management processes generally, and also arranging training for your recruiters and HR advisory staff on the changes and refresher training for your managers on performance management and capability procedures to ensure that everything's properly dealt with and documented. Once we know more about what the rules are, it will be worth reviewing contracts to ensure probationary periods are clear, flexible, and comply with the new rules. The next change is going to be an ending the practice of fire and rehire, which will take effect in October 2026. So I've just mentioned that there are new risks from an increased protective award if you don't consult about plans to fire and rehire in line with the Code of Conduct introduced last year. But there has been a growing concern that employers have carte blanche to vary key contractual rights and obligations by terminating existing contracts of employment and offering re-engagement on new, typically less favourable terms. The government is pressing ahead with plans to make the practice of fire and rehire to change contractual terms automatically unfair, except in very limited circumstances where an employer is in severe financial distress and needs to restructure to remain viable. In those narrow situations, you'd be expected to comply with the Code of Practice on dismissal and re-engagement, that I referred to earlier. However, under the new rules, it will be automatically unfair to dismiss employees for refusing to agree to a variation to their employment contract, or to replace them with another person, or re-engage them under a varied contract to carry out substantially the same duties. This could potentially catch a redundancy exercise where people are dismissed and reapply for jobs if there are changes to terms, and it could also catch a situation where employees are fired and rehired to harmonise terms after a 2P transfer. So what should HR be doing in relation to this? Reviewing contract terms and ensuring that new starters are working on contractual terms that fit your business needs now, and looking for opportunities to update contracts for current employees, for example, on promotion or bonus time. It's worth building flexibility into your employment contracts for new starters, for example, well-drafted contractual flexibility and variation clause. That may well give you some opportunity to change terms of employment without needing to obtain the consent of employees. Keep in mind, though, that there are restrictions on an employer's ability to rely on these types of clauses to make changes, and take legal advice where needed. Okay. Now looking at the change to collective consultation. So as it stands, employers proposing to dismiss as redundant 20 or more employees at one establishment, or site as we'll call it, within a 90-day period must collectively consult with appropriate representatives of those employees before making any redundancies. Redundant, for collective consultation purposes, includes, as you would expect, traditional redundancies, for example, where there's a business closure or a downturn in work, but also employees who face dismissal where their employer is proposing to dismiss and re-engage them on new terms. The proposal is that where 20 or more employees are being made redundant at more than one site, new regulations will set out the threshold for deciding whether the obligation to collectively consult is triggered. How much of an impact this will have on employers will depend on where that threshold is set. We now know that this change is not planned to come into effect until sometime in 2027, which gives more time for everyone to prepare. Employers will not need to consult all employee reps together or to try to reach the same agreement with all representatives, which is presumably to address concerns that the new rules would require representatives to be brought together to be consulted with over separate branches or sites of unconnected redundancies. Alongside this, the government has confirmed it plans to double the penalty, known as the protective award, that it can award, the tribunals can award where employers fail to meet their obligations to collectively consult. It's currently at 90 days, and it will move to 180 days gross pay per employee. That's not capped. That's planned to come into effect in April 2026. The award is designed to be punitive rather than compensatory, and can already be one of the most significant liabilities an employer can face. The potential cost of these claims will increase significantly with the doubling of protective awards. And just to remind you, claims must be brought by the employee rep rather than the individual. The government has committed to issuing further guidance for employers on these collective consultation processes. So what should employers do? So although we don't know yet what the threshold number or percentage will be to trigger the obligation to collectively consult, employers with multiple sites should start thinking about how they can better track and record redundancies across their businesses on a rolling basis, and bear these changes in mind when planning future redundancies and restructures. The consequences of getting it wrong can be severe, but will be even more so when the cap on protective awards is increased to 180 days uncapped pay per affected employee. This really underlines the importance of getting the process right. However, the Court of Appeal has ruled that there is no requirement for non-unionised employers to carry out general workforce consultation in small-scale redundancy processes where there are less than 20 employees proposed to be redundant. So in the case of DeBanks Haycox versus ADP RPO, Mr. DeBanks Haycox was employed in a team of 16 recruitment consultants in ADP's London office when the COVID-19 pandemic led to their sole client implementing a recruitment freeze. Using selection criteria provided by the US company, the team was assessed, and after being ranked lowest, he was ultimately made redundant. The tribunal dismissed his claim that his selection for redundancy was unfair. While it accepted that he knew nothing about his scores until his appeal, it concluded that a thorough investigation into his concerns about scoring had been carried out during the appeal, and he could not show that he had been unfairly selected for redundancy. The EAT upheld the appeal and found that the dismissal was unfair, and it was good industrial relations practice to have a general workforce consultation, and ADP appealed. That went to the Court of Appeal, who allowed the appeal and restored the tribunal's decision. Importantly, it did not agree that there was a requirement for general workforce consultation in small-scale redundancies, so the status quo is preserved. So from a practical point of view, although this decision confirms that general workforce consultation over redundancies of fewer than 20 employees is not compulsory in non-unionised workforces, it makes it clear that what amounts to a fair redundancy process will always depend on the facts. The court also commented that during any redundancy consultation, it's good practice for employers to give employees the opportunity to comment both on the issues which affect them individually, as well as workforce level matters, such as the reasons why they were selected for redundancy and the options for avoiding the redundancy, respectively. So I'll now hand over to Matt, who will talk you through the next points.
Thank you, Laura. Hi, everyone. Now let's look at the proposed changes relating to diversity, equity and inclusion. Firstly, I'd like to mention gender pay gap reporting. So under the Employment Rights Bill, the government plans to introduce from 2027 a requirement for large employers, which is those with 250 employees or more, to create action plans to address gender pay gaps. The content of those action plans will be a matter for regulations that we haven't yet seen, but this may mean that employers need to start thinking strategically about and document how to go about reducing their gender pay gaps to improve gender equality and opportunity, and how such a plan might feed into an assessment of broad themes such as an employer's recruitment, retention, pay and promotion. The government also plans to require employers to identify the providers of contract workers when publishing their gender pay gap reports, where that provider is also an entity that is caught by the requirement to report. And the idea there is that the reporting would show that the two organisations are ones that are linked. We don't yet know when that particular proposal is scheduled to come into force. The second point in this space is ethnicity and disability pay gap reforms. The government proposes to introduce a separate bill from the Employment Rights Bill that will deal with this and pay gap reporting in this area. What that will do is make it mandatory for large employers, again those with 250 or more employees, to report their ethnicity and disability pay gaps. It will also extend equal pay protections to protect workers who suffer discrimination on the basis of their race or disability. A consultation on ethnicity and pay gap reporting has been published, and it states that the government's aim is to use a similar reporting framework as currently applies for gender pay gap reporting to apply to ethnicity and disability gap reporting. So in essence, that requires employers to do much the same thing in terms of using the same processes and systems that are already in place for gender pay gap reporting, such as reporting the same set of gender pay gap measures, using the same reporting dates, and doing so online. The proposal will also make it mandatory for employers who are caught by this obligation to report the overall breakdown of their workforce by ethnicity and disability, and the percentage of employees who did not disclose their personal data on their ethnicity and disability. Third point is that it will introduce additional reporting requirements on ethnicity and disability for public bodies, such as in relation to recruitment, retention and progression. The consultation does recognise, which I think is the really critical point with this type of reporting, that there are additional considerations for ethnicity and disability pay gap reporting, including some quite challenging practicalities relating to data collection and privacy concerns, which can arise where there is a small data set, which is obviously inherently more likely when you're talking about getting people to describe their ethnicity or disability. We think this is going to be a really challenging area for employers, not least because, as I just indicated, ethnicity and disability are typically more difficult to define in the clear manner that gender is. Thirdly, the government has proposed that they'll put in place measures to ensure that outsourcing of services can no longer be used to circumvent equal pay requirements, including providing work of equal value to women. So we don't yet know what that proposal looks like in practice either, but it's one to look out for in due course. And it underscores that the government is really looking closely at equal pay as an issue. This also relates to the final point on the slide, which is that the government intends to set up what it is calling the Equal Pay Regulatory and Enforcement Unit to strengthen the enforcement of equal pay rights. This again carries on from the broad theme under the Employment Rights Bill that there will be a stronger enforcement framework for employment rights in the UK. Moving on now to workplace culture. The bill introduces a significant new protection for harassment, and in particular, a new liability for employers relating to harassment of their employees during the course of their employment by third parties. So that includes customers, suppliers, or clients, and the like. It's not limited to sexual harassment, and there will be a defence to this type of claim in relation to third-party harassment if the employer can show that it has taken all reasonable steps to prevent that third party from doing so, which really sets a very high bar. This change is planned to come into effect in October 2026. Currently, employees cannot claim against their employer if they're harassed by a third party in the course of their employment. But the current preventative duty, which Laura mentioned, requires employers to take reasonable steps to prevent sexual harassment. So that does in practice mean that the preventative duty that currently applies means that employers are required to take some reasonable steps to protect their employees from sexual harassment by third parties. The bill also expands the current preventative duty by requiring employers to take all reasonable steps to prevent sexual harassment. So rather than just the reasonable steps that the current preventative duty mentions. Again, this is also planned to come into effect in October 2026. The government is going to define reasonable steps through further regulations, which are likely to include things like risk assessments, action plans, and complaint handling procedures. So it's a similar set of steps to what the preventative duty has required. Additionally, from April 2026, reports of sexual harassment will be covered under the whistleblowing framework. So that's an additional layer of protection for employees. So overall, this is clearly quite a significant shift in responsibility for employers, going beyond the preventative duty change last year. And this is particularly going to be the case for those employers who typically operate in a public-facing setting. Clearly, what employers need to do to prepare for these changes will largely be guided by the detail of these changes, which we're yet to see. But what we can anticipate is that these work streams are going to require you to review and update the sorts of things that were considered for the preventative duty last year. So that is things like harassment policies and reporting procedures, looking at your risk assessment documentation, and the content and components of your employee and manager training, all of which should still be relatively fresh for employers, having looked at this, as I say, last year. We thought it would be good to give you a couple of examples of recent tribunal claims, just to show how these tend to be handled by the tribunal, and not least to illustrate the sorts of fine differences that can exist on the facts of any given case. The first is a case called Chen and Cut Your Wolf Loose Limited, in which the tribunal found that an air kiss was not unwanted conduct relating to sex and therefore was not sexual harassment. The claimant in the case, Ms. Chen, worked for a specialist whiskey bar and shop, and the assistant manager of the shop often walked her home at the end of her shifts. She did not complain at the time, but after being given notice of her dismissal, she alleged that on 2 previous occasions on these walks home, he, the assistant manager, had kissed her intimately on the neck, which he denied, saying that he had hugged her and given her an air kiss. Ms. Chen subsequently brought claims, including for unfair dismissal, sexual and racial harassment. On the evidence, the tribunal concluded that the manager's versions of events were the more credible. It found that an ear kiss was not, on the facts, unwanted conduct relating to sex, or I should say unwanted conduct relating to a sexual nature. And even if it was sexual in nature, that it wasn't reasonable for Ms. Chen's dignity and her rights to a absence of a degrading workplace environment to have been violated. In another case, the wonderfully named British Bung Company and Finn, the Employment Appeal Tribunal held that the comments about a male employee's baldness were unwanted conduct relating to sex and were therefore sexual harassment. Mr. Finn had been called a bald expletive, the expletive being the C word, by his colleague Mr. King, and threatened with violence. He subsequently brought claims, including for harassment relating to sex. The tribunal found that that conduct amounted to harassment. Although the employer did argue that baldness is not strictly speaking a male characteristic, the tribunal had found that there was a connection between the word bald and the protected characteristic of sex. And on appeal, the EAT agreed with that position, and the fact that something could potentially apply to both sexes did not necessarily mean that it wasn't inherently related to one sex over the other. And so the EAT accepted that baldness is more prevalent in men, and therefore that was inherently related to the claimant's sex. So these cases illustrate that decisions on harassment are really fact dependent, and that it's critical to ensure that in order to prevent these sorts of claims being brought, that your employees understand and are trained in what is appropriate in the workplace, that you have suitable policies to address that, and that your workplace culture is consistent with what those policies require. And of course, this is going to be even more crucial when you overlay this against the sorts of changes that are coming into force in the next 18 months or so. Next slide, please. So moving on to family-friendly rights, the Employment Rights Bill introduces day one rights for workers to paternity leave, which is a change that will be introduced in 2026 in April. Secondly, to unpaid parental leave, again, a change scheduled for April 2026. And in terms of what that means, that is giving parents up to 18 weeks of unpaid leave at the rate of up to 4 weeks per year for each child they have over the course of their childhood. Thirdly, unpaid bereavement leave is a day one right, and it is proposed that unpaid bereavement leave, which is currently something only available to bereaved parents, will be extended so that all bereaved workers are entitled to unpaid leave at the rate of at least 1 week for each bereavement. And that looks likely to be introduced in 2027. Separately, there is also a plan for a new day one right to paternity bereavement leave under a new law that was passed last year, but which has not yet been brought into effect. What that will do is give new rights to bereaved fathers and partners where a child's mother dies. And the usual 26-week minimum service requirement for eligible paternity leave individuals would not apply to fathers and parents and partners, I should say, in that case where the mother has died in the first year after a birth or adoption. So what should employers be doing in preparation for this now? So firstly, in relation to paternity bereavement leave, look out for further details and the implementation date for this new type of leave. And when those details are fleshed out, obviously it's going to require a review and update for your paternity and bereavement leave policies. The bill also includes measures to protect from dismissal any women who are pregnant, on maternity or other family leave during such leave and during the period for 6 months after their return to work, with some specific exceptions. The government has also given further insight into these plans. An amendment to the bill provides for regulations to be set out with specific notices and other procedures that will need to be followed. The explanatory notes indicate that the intention is to ban such dismissals except in very specific circumstances. We will need to see the regulations to understand exactly what the practical implications of this are. Lastly on this, I will mention the review of parental leave, which has just been launched, as many of you will have heard, on the 1st of July. The government has launched this full review of parental leave and pay, which is anticipated to take 18 months, and will look at all types of family leave, including maternity, paternity, and shared parental leave, with the aim of making the entire system fairer and easier to use. So what we can expect is that this review will try and mitigate the complexity of family leave arrangements, and it seems very likely that paternity leave and pay plus shared parental leave and pay are going to be the key topics being scrutinised, given that the review calls out the limited take-up of those types of leave in addition to the complexity of the current regime as a whole. Moving on to SSP and enhanced rights to that, which are expected to come into force in April 2026. Currently, SSP is payable only from day 4 of sickness absence, and employees need to earn at least £123 a week to qualify. The government plans to scrap the waiting period for SSP, and so SSP will be payable from the first day of absence, and also to remove the lower earnings limit to make sick pay accessible for lower earners. This means that all employees will be entitled to the lower of the or 80% of their average earnings as soon as they are off sick from work. The goal behind this is to achieve a balance whereby lower earners are not completely excluded from the SSP regime, but equally are not better off by being off on SSP than they would be by working. So some employers will see this as a step in the right direction. Obviously, employees will. And what it, of course, does is change the position for those who experience short-term periods of ill health. However, the risk for some employers could certainly be a spike in short-term periods of absence and attendance issues because the promise of some pay, even at SSP rates, from day one and during absences of any duration, could act as an incentive for certain employees to take unnecessary time off work. In terms of what employers should be doing to prepare, again, we recommend reviewing and updating your sickness absence policies and procedures to deal with this. And these changes are, of course, going to underscore the importance of good absence management practice. In practical terms, the changes to SSP payment arrangements are going to require employers to interface with their payroll teams or payroll providers to ensure that these changes are implemented in good time. Moving on to menopause support. So increased awareness about the menopause has really led to a significant increase in the number of tribunal cases on this topic in the last few years. So as well as presenting a clear litigation risk, it's also become a real reputational issue for employers that don't set forth a proper agenda in the space. So the bill introduces a requirement for large employers with at least 250 employees to produce and publish a menopause action plan. It's currently anticipated that this requirement will come into force in 2027, so a similar timeline to the gender pay gap reporting measures. So we recommend looking out for the consultation on this topic, which is expected, and then once the parameters of an action plan are defined, then employers will need to start to think about what that plan should contain, building on any policy procedures or other measures they have in place to do with the menopause. Lastly, on this slide, I wanted to cover flexible working. As you will know, currently employees have a day one right to make flexible working requests and can do so twice each year. Employers are required to respond to those requests in a reasonable manner and can only turn down those requests based on one or more of the 8 prescribed business reasons. So under plans which the government says will be implemented now in 2027, employers will only be able to refuse requests if it is reasonable to do so, based upon one or more of those same 8 prescribed reasons. The policy intent here is that flexible working should be the quote-unquote default unless the refusal is reasonable, and that employers will have to explain why they believe the refusal is reasonable based on the particular grounds relied on. The key point here really is that the flexible working as the default is not necessarily quite as strict as it first sounds, because the takeaway here is that employers will have discretion to assess requests based upon those business reasons that currently exist, and will need to have reasonable grounds for refusing any request. There's also not going to be any change to the penalty regime for breach of flexible working rules, which is currently capped at a maximum of 8 weeks' pay, £5,600 in total. As many of you will know, currently the real risk for employers in this area relates to the potential for indirect discrimination claims, where flexible working requests are turned down, rather than from claims to breaches of the regime and the rules within it themselves. And we think that position is really unlikely to change based on what we can see in the government's proposals. Turning now to 0 or low hours contracts and agency workers. One of the focal points of Labour's reform agenda is job security and predictability. Initially, there was talk of banning 0 hours contracts, and it's now clear that the government has walked that position back. And the bill introduces a series of protections instead for those on 0 or low hours contracts. And what this means is there will be a new duty for employers to offer guaranteed hours contracts after a certain period, providing reasonable notice of shifts and compensating workers for short notice of cancellation, postponement, or shortening of shifts. The detail of how this will all work for employees on 0 or low hours contracts is again going to be set out in regulations. And these changes are also in the category which are expected to be implemented in 2027. To address a potential loophole whereby employers could circumvent these protections by using agency workers, the government is intending that these same protections will also apply to agency workers. So they too will have this right to be offered a guaranteed hours contract as well as the right to have reasonable notice of changes to shifts and of notice to shifts themselves. The obligation to provide a guaranteed hours contract in that setting will rest with the hirer, that is, the end user of the agency workers' services. The reason for that is on the basis that they are the party best placed to predict the amount of work in the pipeline. Practically, the hirer and the agency are going to have to share responsibility for providing reasonable notice of shifts. How this quite operates in practice remains to be seen, because the regulations again will specify the form and way in which workers should receive notice of shifts and any shift cancellations, curtailments or movements. Finally, it has also been decided that agency workers will be eligible for compensation for shifts cancelled or changed at short notice, and that responsibility for making those payments will fall to the agency. Obviously, that is going to be unwelcome news for agencies, as typically these sorts of things would have been the remit of the hirer in terms of cancelling or curtailing a shift, and the agency would have no power to influence the situation. However, they are the ones now having to foot the bill. And the government has confirmed, however, that agencies will have the ability to recoup those payments in certain circumstances. Another key change is that a collective agreement will be one way in which parties can contract out of these rights to guaranteed hours and reasonable notice of shifts for both workers and agency workers. So that will enable an employer and a recognised trade union to reach a different agreement and exclude these new rights and agree something else, as long as those terms are incorporated into the collective agreement. There's clearly a lot of detail that's going to need to sit in these regulations relating to zero and low hours contracts, and also for us to determine exactly what the impact is going to be. It's certainly not clear at this point how these rules are going to take account of sectors that have busy periods throughout the course of a year and fluctuating levels of work, such as retail and hospitality over the Christmas period, or any transport or logistics providers that have seasonal busy periods. So for employers with zero or low hours contract workers, what can you do to prepare for this at this point? So we think the first step really is to start to audit your workforce to identify which groupings of employees and agency workers are potentially caught by these changes. And we think you can at least start to model some scenarios using particular reference periods and typical incidences of shift changes or cancellations to assess where your risks and costs might be under this revised regime. Ultimately, as more details emerge, you'll be able to refine that analysis. It may ultimately require a wholesale review of how you deal with labour supply because of the significance of these changes. I'll hand over now to Stephen to speak about changes relating to trade unions.
Thank you, Matt. And in a moment or two, I'll be looking at the timetable for all these changes you've been hearing about. But as you say, Matt, I'm going to look now at trade unions, because the Labour government has made no secret of the fact that it intends to reform trade union law. And before we look at what they're planning to do, let's have a quick resume of what happens at the present time. And it's correct to say employers currently have very, very limited obligations to notify their workers of their right to join a trade union. And in addition, there's currently no right for trade unions to access the workplace for the purpose of recruiting members and for organising those members once they recruit them. And if you add to that the fact that the thresholds for obtaining statutory recognition can at times be challenging for unions to meet, you can understand why they have put pressure on the government to advance these changes. So the changes that the government has said it wants to make to strengthen the power and reach of the unions consist of the following main elements. Starting with the written statement, and you'll all be familiar with the written statement that's issued to employees when they start with you. Well, the Employment Rights Bill is going to require employers to include in that written statement advice or information that the worker has the right to join a trade union. And looking to access, that is the access of the trade union to the prospective members, your workforce, from October 2026, under the current plans, trade unions would have the right to access your workplace for the purpose of meeting, recruiting, or organising workers, or facilitating collective bargaining once they obtain recognition. And access in this context means the physical access to the workplace, and it is potentially communication with workers by any other means. And that means that access could include digital access, the detail of which is going to, or has been promised in regulations. Now, the access would be organised through legally enforceable agreements between the employer and the union, or if the employer and the union are unable to reach an agreement, the Central Arbitration Committee, which is the body charged with dealing with these disputes, would issue a decision binding on both parties. And in addition, new penalties are planned where an employer breaches a trade union's right of access to the workplace, just to reinforce the importance of the new right. And separate regulations will be needed to bring those changes into force. But taken together, these changes are obviously going to mean that trade unions will have a bigger role to play in employee relations in the future. And thinking ahead to that and addressing some of the issues you might want to look at while we await the detail is you may want to assess your employee relations strategy and how you currently engage with your staff on a collective level. Because obviously if they're content with the collective arrangements, they're less likely to vote in a trade union. So you could consider putting in place other employee bodies such as forums or councils if you think they would be more representative of your workforce and allow those workers to express their voice without the need of an intervening trade union. And on the subject of recognition, from April 2026, there's no longer going to be a requirement that in the ballot that the trade union can show 40% of the employees in the bargaining unit, even those who haven't voted. And so in the vision of the future that we've been told about, it's going to be a simple majority of those voting, and turnouts in these ballots tend to be low. And then turning to strikes. At the moment, there's existing minimum service legislation which allows the government to set minimum service levels during strikes in essential services. And the Trade Union Act of 2016 imposed various additional requirements for trade unions organising industrial action, including, for example, longer notice periods, higher ballot thresholds, and increased information provision to employers. Well, may not surprise you to learn that under the bill, these minimum services protections are going to be fully repealed. And once all these changes come in, there'll be a delay of approximately 2 months, at which point we're expecting further changes. For instance, reducing the information required in industrial action ballot notices. And if you've ever been in the receiving end of one of these, you'll realise even at present, they can be fairly sparse in terms of detail. They're also going to reduce the notice a trade union needs to give before strike action begins from 14 to 10 days. And as you probably already know, once a ballot is successful, that essentially provides the trade union with 6 months within which to call action. Well, one of the proposed changes is to double that to 12 months. And in due course, there also is a commitment to introduce e-balloting. Now, that sounds like a very technical change, but as you've perhaps encountered before, one of the major obstacles for a trade union in planning industrial action is the simple cost of the ballot itself, because it has to be the result has to be independently verified. And finally, the government has said it's going to introduce protections for workers against any detriment short of dismissal for taking part in industrial action. And that has been anticipated for a while, and so should not be a surprise. So taking them all together, these changes will, as I said at the start, make it easier for trade unions to threaten and take industrial action and to contribute to your industrial relations agenda. It's going to make it easier for trade unions to access the workforce and gain recognitions, and it would be no exaggeration to say bring about a shift of power between unions and employers to the benefit of the unions. So, as I said when I resumed my presentation, I was wanted to cover in a single slide the timetable, because this month has seen an update from the government as to what's happening and when. And you'll see that on the slide at the moment. And one thing's clear, that most of the provisions will not come into effect immediately when it's passed, because many of the changes are going to require separate commencement regulations to bring them into force, and much of the detail is still to be set out in substantive regulations, some of which will require further consultation. And taking all that together, the majority of the reforms are anticipated to take effect from 2026, with some changes happening sooner, for instance, regarding minimum service levels and strikes, which we've just been discussing. And in fact, some of the other union-related provisions have been accelerated and are going to be 2026. But the point that surprised us is that the more headline-grabbing changes around zero-hour contracts and day one unfair dismissal rights are very possibly not going to come into effect until some point in 2027. And so there'll be a number of webinars from us between then and now, which will update you on the changes, because there's clearly some scope for further changes to take place. So we've reached the point where I'd like to turn our attention away from statutory changes in government plans to look at probably one of the most basic questions applicable to any workforce or workplace. And I'm going to cover the case of 4 Women Scotland Limited against the Scottish ministers. And I can't believe anyone has not heard of this case in some context. But I wanted to go through a couple of the basics and also set some ground rules about my own presentation, because to call this area controversial would be an understatement. Now, the question which the Supreme Court ultimately had to decide was whether the 2010 Equality Act, which treats a woman with whether it treats a trans woman with a gender recognition certificate as a woman for all purposes, or when that act speaks of a woman and sex, it is referring to a biological woman and biological sex. And so those are the key questions. What I have to say at the outset, bearing in mind what I'm going to be covering before I finish, is that the Supreme Court was not asked about the provision of single-sex toilet facilities, but we'll come to that. And so, as I say, housekeeping. This is a sensitive topic. Many people have strong views about it. Many people have very strong views about it. And the language I'm going to use is reflective of that used in the Supreme Court judgment. For example, when I say a phrase like biological man, I'm referring to a trans woman, and conversely, biological woman is referring to a trans man. The phrase biological sex I'll use to describe a person's sex at birth. Certified sex, in contrast, to describe the sex attained by the acquisition of a gender recognition certificate. And so, looking back at how this particular case started, it was a progressive measure introduced by the Scottish Government to increase the proportion of women sitting on public sector boards, publicly financed. And for Women Scotland as a pressure group, which challenged the fact that when it came to the definition of woman to increase the presence of women on public boards, the definition of woman, according to the Scottish Government's guidance, included a trans woman. And as I said earlier, that's controversial. The case made its way through the Scottish courts and ended up with the Supreme Court. And you'll be aware that the Equality Act protects employees and workers from discrimination, but it also, in a separate section, prohibits goods and services being provided to the public in a discriminatory manner. And the Supreme Court, after analysing several aspects of the Equality Act, unanimously concluded that the Equality Act definition of man, woman and sex is biological sex and not certificated sex. And the court said any other interpretation would make the Equality Act internally incoherent and impracticable to operate. And so whatever your position is in this argument, we've at least got to commend the court for being so decisive, and not that it's ruled out all the controversial questions, as we'll see. And one of the things the Supreme Court did, aware of the various pressure groups, was that as part of the judgment, they stressed that trans people, and that's people with or without a gender recognition certificate for these purposes, continue to be protected from discrimination and harassment under the separate protected characteristic of gender reassignment. Trans people also continue to be protected where they are discriminated against or harassed because of their perceived sex. They also continue to have privacy rights in relation to their previous gender, which is classed as special category personal data under UK data protection legislation. Now, hardly needs saying, but I'll say it anyway, the key in dealing with implications of this case is to ensure all staff feel supported and treated with respect. So I'll give you some of our thoughts about steps that should be taken following the decision. Thinking first and foremost about policies and procedures. And it's worth making sure you know what policies you have on what topics that this case touches on, because it's not always just equality policies, so that when the guidance is updated further, you can make any relevant changes. And by guidance, I mean the EHRC guidance, which I'll talk about in some more detail later. Employers should continue to ensure that all staff, including any trans people, are treated with dignity and protected from discrimination and harassment. Thinking back to some of the things that have been covered earlier in the presentation. Comparators and discrimination claims is an important subject too, because as you know, in direct discrimination claims, equal pay claims, an individual claimant has to identify a comparator. And if a claim involves gender reassignment, the correct comparator is key to determining whether or not discrimination has occurred. And one of the results of the Supreme Court's decision is that it's likely to be very influential in determining the correct comparator for a gender reassignment claimant to use in a discrimination going forwards. For example, a trans woman may not be able to use a man as a comparator in an equal pay claim. Another section of the Equality Act, which is often referred to in this context, is the so-called genuine occupational requirement. Those are the very limited circumstances where it is acceptable to advertise for an employee of a particular sex. For example, advertising a role supporting vulnerable women. Another result of the Supreme Court ruling is that the employer in that situation will be able lawfully to exclude trans people with that acquired gender, even where they hold a gender recognition certificate. Now, even though that seems the likely result, we still recommend taking legal advice should you choose to pursue a gender-specific occupation. And one of the things we've seen is that because there's so many pressure groups in this area, there's an increase in crowd-funded litigants who are literally trying to prove a point, and you don't necessarily want to find yourself in a litigation, which is part of a more general campaign. Another aspect, again, positive action. where there's underrepresentation of one or other group, and there are certain circumstances where an employer can take positive action without that being positive discrimination. And so where we have positive action measures aimed at supporting those of a particular sex to overcome disadvantage, and as I say, this is permissible, these positive action programs will be able to exclude trans people holding a gender recognition certificate in that sex. But again, I suggest taking advice just to make sure you get it absolutely right. Turning next to service providers, associations and charities, the judgment is also going to be important in determining whether employers who are service providers, associations or charities, if they're able to lawfully exclude trans people, regardless of whether they have a full gender recognition certificate, where the Equality Act provides for separate single-sex services. And finally, in this subcategory of items in the Equality Act, we've got gender pay gap reporting. And we think the decision is also going to have significance there. Despite the fact that the gender pay gap regulations don't presently define the terms male and female, there is government guidance how to record an employee's gender for gender pay gap reporting purposes. And that suggests that a person's gender depends how they self-identify. And as there's clearly a clash, therefore, with the Equality Act, it may be that that guidance is updated in future in the light of the Supreme Court decision. And so I appreciate that no one joined HR to become a toilet monitor, but we do have to cover the subject of single-sex spaces. In fact, in many respects, that's where the debate and discussion has moved to. And it's worth underlining again, therefore, that the decision doesn't make any direct ruling about single-sex spaces, including toilets, changing, and for some employers, washing facilities. And that's because the decision is about the meaning of sex in the Equality Act. And it's not the Equality Act that determines the facilities you should have in your workplace for the different sexes. That's dealt with by a health and safety regulation dating from 1992. And in April, the Equality and Human Rights Commission published an interim update on the practical implications of the Supreme Court decision, and it had a particular focus on single-sex facilities in workplaces. And at the end of last month, an updated version was published by the Commission, which focused on these 1992 regulations. And what attracted our attention is the original April update had told employers it's compulsory to provide sufficient single-sex toilets as well as sufficient single-sex changing and washing facilities. Well, that has been significantly changed, and now the Commission document simply restates the 1992 regulations. And those regulations, the uncontroversial point, says that men and women should have separate facilities unless each facility is in a separate room with a lockable door, etc., etc. The difficulty is that these regulations don't define men and women for these purposes. And it doesn't automatically follow that the definition of men and women is going to follow what the Supreme Court held as appropriate in the Equality Act. And so this is clearly going to continue to be an active area for discussion and ideally agreement with your own workforces. Making this more difficult is that the EHRC Commission document refers to workplaces and services that are open to the public. Now, services that are open to the public, understand what that means, but there's currently a debate outside and inside our office as to whether they mean to say workplaces that are open to the public or just workplaces. And as you can imagine, there's a hugely significant difference in those two alternative definitions. So, we think that, in short, there is a lot of ambiguity in the interim update. And as you may know, the Commission at the end of June closed a consultation which they were running separately, which in due course is going to lead to guidance. And I think the answer is to await the guidance if at all possible, because the Commission has stated that the update, important though it is, and controversial though it is not guidance. And so looking to what we can predict, at some point there is going to be another case or legislation or guidance which specifically addresses this question of what does the 1992 regulation mean when it refers to men and women? Is it biological sex or not? And as I say, even in our own office, we've got different opinions of what that means. And so obviously that signals that we should be treading with care. And just as important, we need to know whether the Commission mean all workplaces or just workplaces which are open to the public. Restaurant, for instance, is an obvious, easy example. So until we get that further guidance, employers are in a difficult position of having to decide for themselves how to implement the Supreme Court decision, in the knowledge that there isn't an option which is free of controversy and risk. And claims are still possible because the Equality Act does not give the employers the protection from trans-related discrimination claims that is given to service providers. And so this means that as things stand, there are potentially risks of sex or belief discrimination claims if employers operate a trans-inclusive approach to toilet washing and changing facilities. And conversely, if they don't, risks of gender reassignment discrimination claims if they move away from more inclusive provision following the Supreme Court decision, leading to a difficult balancing act. In the longer term, moving towards mixed-sex toilet washing, changing facilities with individual lockable rooms may address these challenges. But obviously these facilities can't be created overnight, and there will be uncertainties in the short term. One point that just come up in our own discussions with clients to date is redesignating existing single-sex toilets as, for instance, unisex or inclusive. But that would be unlikely to meet the HSE conditions for mixed-sex toilets. In many workplaces, there are either no mixed-sex facilities at all, or the only mixed-sex facility is the toilet provided for disabled people. Now, as I said, the Commission is working on updated guidance, and its aim is to provide an updated code of practice to the UK government by summer for ministerial approval ahead of the full draft code being laid in Parliament after the summer recess. Now, I can imagine all of us are united in hoping that provides us with the clarity on how to move to manage these various scenarios that these complex and sensitive issues continue to present. And you see there a summary of what's going to happen, at least as we know today, July, with these various measures. And this will be available for you in the deck that's sent out to confirm the position. And so that concludes the formal presentations for today. And on behalf of Matt and Laura and myself, thank you for listening, and I'm hoping you took away something interesting from what we said, maybe a few questions to consider. And as I said at the outset, if you want to use the Q&A box to post some questions for us, we'll be happy to deal with this either today during the session or if not afterwards. Thank you very much.